Welcome to the second part of our two-part webinar series discussing significant construction and adjudication cases of 2021. These webinars aim to cover key developments in construction and adjudication practice during 2021 and how these might affect your construction project disputes in 2022 and beyond. The webinar today will focus on our chosen top 5 adjudication cases of 2021. We will highlight the main facts and legal points from each and identify specific lessons to be aware of for construction contracts and claims. This webinar is pre-recorded. However, if you would like to ask a question, we would be happy to address any queries after the webinar by phone or email. Our contact details are noted on the next slide. I am Nathaniel Buckingham, a Senior Associate specialising in construction and engineering dispute resolution, and I'm joined today by my colleagues Chiara Pieri and Tara Davison, both solicitors in our team. Our team regularly advises on construction contract issues and disputes across a range of projects and clients. We therefore have a great deal of experience in litigation, arbitration, adjudication and mediation, where our arguments have to reflect ever-evolving judicial approaches to construction law and contracts. That experience, particularly adjudication experience, forms the basis of our advice and analysis in the webinar today. I'll now pass you over to Chiara, who will run through the agenda for today's webinar.
Thanks, Nathaniel. So the first case we're going to discuss is Denton Development LLP against Laxman by Construction UK Limited. We take from it useful lessons about issuing payment notices and the failure of an adjudicator to consider a line of defence. We will then move on to Toppan Holdings Limited and Abbey Healthcare Mill Hill Limited against Simply Construct UK LLP, in which the court considered an adjudicator's decision as to whether a collateral warranty was a construction contract for the purposes of the 1996 Act. The third case we'll look at is the case of John Doyle Construction JC against Erith Contractors Limited, which provides some guidance on the enforcement of an adjudication decision in favour of an insolvent entity. Our fourth case is Quadro Services Limited against Crea Concrete Products Limited. In it, the court held that failure to make payment in respect of 3 separate payment applications was one dispute for the purposes of adjudication. And the fifth and final case we'll consider is Transport for Greater Manchester against Kier Construction Limited, trading as Kier Construction Northern, which considered whether a notice of dissatisfaction with an adjudication decision had been effectively issued. So our first top adjudication case of 2021 is the case of Denton Development LLP against Laxman by Construction UK Limited. So first, some background to the dispute. Denton Development LLP was the employer in this contract, and they engaged Laxman by Construction UK Limited in connection with the demolition of buildings and development of land under an amended JCT design and build contract. Under the contract, a periodic payment scheme required Laxman by to make interim applications for payment. When a dispute arose concerning the corrects due under its interim application 34, the employer issued a payment notice 34, assessing a net payment due of 97p. This was accompanied by a covering letter stating that a further notice would be issued in due course. 6 days later, payment notice 34A followed, which assessed a net payment of £650,218.50, some £600,000 greater than the original amount. Laxman by submitted the matter to adjudication for a determination of the corrects due, and the employer submitted a cross-claim alleging losses suffered resulting from breaches of contract, including the non-provision of a warranty and defects in the design and build of a capping beam. The adjudicator made a decision on the net sum due, but held that he did not have jurisdiction to consider the cross-claim. So the employer then raised a claim in the TCC seeking a declaration that the adjudicator's failure to address the cross-claim was a breach of natural justice, and that as a result, the adjudicator's decision as a whole was unenforceable. The employer separately contended that the adjudicator's decision could be seen as two distinct decisions on separate issues, namely a decision on the sum due in respect of the payment application and a decision on the counterclaim. The employer argued that the effective counterclaim decision could be severed, leaving the adjudicator's decision on the sums due, which should be enforceable. In this way, the employer hopes to prevent the contractor relying on interim application 34 as originally formulated on a smash and grab basis. So what did the court decide? Well, the TCC held that payment notice 34, which was the original notice, was invalid because it did not accurately state the sum the employer considered to be due. It therefore did not comply with the requirements of Section 110A of the 1996 Act. Rather, payment notice 34 was in fact a holding position, which was evident from the covering email, which stated that a further notice would be issued, and the issue of payment notice 34A 6 days later and for a substantial sum, which was the £657,218 figure in comparison to the 97 pence, which was certified in payment notice 34. The second point that the TCC considered and held was that the adjudicator had jurisdiction to consider the employer's cross-claim, and the failure to exercise it amounted to a deliberate failure to address the material issue. Doing so was a breach of natural justice. Consequently, the decision as a whole was unenforceable. Had the adjudicator inadvertently failed to consider one of a number of issues, this would not ordinarily render the decision unenforceable in England. As an aside, this does mark a difference with recent case law in Scotland, where even an inadvertent error in failing to exhaust jurisdiction has been seen to render a decision unenforceable. So thirdly, the TCC held that it was not possible to sever the part of the decision that related to the counterclaim while enforcing the rest of the decision. This was because in the case and on these facts, enforcing one part of the adjudicator's decision without the other would be artificial and inappropriate. The adjudicator had not been engaged in making a series of separate and potentially severable decisions. Rather, he was engaged in reaching a single decision that could not be severed into parts. So what can we take away from this decision? I think the case highlights 2 points. One in relation to the issuing of payment notices and the other in relation to adjudicators' decisions. So first, contract administrators should take care when issuing payment notices. They must be thorough, complete and issued on time, otherwise they may be found to be invalid. That might leave the employer vulnerable to a smash and grab claim. Essentially, the lesson is not only to make sure that when issuing a payment notice that it does not itself contain comments which suggest that the amount does not truly reflect what is due, but also that any emails, minutes, project correspondence around that time also do not suggest this. If there is any sense that the payment notice is simply a holding position, this decision suggests that the notice will not be valid. Conversely, for contractors, if any of your project teams receive a notice that contain language like this, then they should seek advice, as there may be potential arguments that the notice was not valid. Lastly, parties should be aware of the consequences of an adjudicator's decision to restrict jurisdiction. The case of Downs Road shows how incorrect failure to consider an issue can result in a decision that's unenforceable. I'll pass you on to Tara, who will talk about our second case.
The second case we're going to look at is Toppan Holdings Limited and Abbey Healthcare Mill Hill Limited against Simply Construct UK LLP. This is an adjudication and enforcement case in which the TCC considered whether a collateral warranty was a construction contract within the meaning of the 1996 Act. Simply Construct entered into a design and build contract with Sapphire Building Services Limited for the construction of Arundel Manor, a luxury care home in Mill Hill, London. Sapphire then transferred its rights and obligations under the contract to Toppan, the owner of the home, and Toppan entered into a long lease with Abbey. Abbey became the tenant and operator. Defects became apparent, and Toppan requested that Simply Construct remedy them. When Simply Construct did not, Toppan engaged a third party to carry out the works. Toppan and Abbey both then raised separate adjudication proceedings against Simply Construct. Toppan's adjudication proceeded under the building's contract with Simply Construct. Abbey's adjudication proceeded under the Simply Construct to Abbey collateral warranty. Toppan and Abbey were both successful at adjudication. Simply Construct failed to make payment to Abbey, and enforcement proceedings were commenced. Simply Construct argued that the collateral warranty was not a construction contract and therefore did not give rise to a statutory right to adjudication under the 1996 Act. It noted that the collateral warranty was only executed after the defects had been remedied. In reaching its decision, the court noted several points of principle, including, firstly, a construction contract need not be wholly or even partly prospective. Secondly, Parliament intended a wide definition for construction contracts, so peculiarly syntactical analysis of the statute should be avoided. Thirdly, where a party agrees to carry out and complete construction operations, it will invariably be an agreement for the carrying out of construction operations, which would be a construction contract under the 1996 Act. And finally, attention must be paid to the wording and relevant factual background of individual warranties. The court referred to two particular pointers in assessing whether any particular agreement is a construction contract. Firstly, a very strong pointer is whether or not the relevant contractor is undertaking to the beneficiary of the warranty to carry out construction operations. And secondly, a pointer against the existence of construction contract may be that all the works are completed and the contractor is simply warranting a past state of affairs as reaching a certain level, quality, or standard. Considering these factors, the TCC held that the collateral warranty was not a construction contract and therefore adjudication was not a statutory right in terms of the 1996 Act. When the warranty was executed, it was some 4 years after practical completion of the build and 8 months after completion of the remedial works that were the subject of the adjudication. The warranty was entirely post-construction, at which point no further works were being carried out. This was a pointer against it being considered a construction contract. Thus, though Abbey could still bring a court action against Simply Construct, it had no obligation to pursue an adjudication. The adjudication decision was therefore unenforceable. What can we take away from this case? Well, it is clear that whether a collateral warranty confers a right to adjudication will turn on the specifics of the case. However, parties who wish to have a right to adjudicate under a collateral warranty should consider the following 3 pointers. Firstly, the express provision. In this case, Abbey sought to imply the right to adjudicate into the collateral warranty because it was not expressed. Had the collateral warranty contained its own adjudication clause, then there would have been no debate about whether adjudication was competent. Whether such a clause is appropriate for parties will depend on the warranty in question. Secondly, early execution. The case suggests, generally speaking, the earlier a collateral warranty is executed, the greater the chance of it being considered a construction contract, and vice versa. If there are still construction operations to be completed, a warranty will be at least partly prospective and more likely to be deemed an agreement for the carrying out of construction operations. And lastly, remedying the defects. One of 3 pointers of relevant factual background in this case was that the remedial works to the disputed defects had been completed by another contractor months before the Abbey collateral warranty had been executed. Parties who may wish to argue that a collateral warranty is a construction contract should think carefully about the timing of any remedial works being carried out. Carrying out all works before any collateral warranty is entered into may remove any argument that there are outstanding construction operations and therefore close off the path to adjudication. I'll now pass you on to Nathaniel, who's going to talk through the John Doyle construction against Erith Contractors Limited case.
Thanks, Tara. So this is the third case, John Doyle against Erith Contractors. John Doyle was a subcontractor engaged by Erith to provide hard landscaping works under an NEC contract. John Doyle entered administration, did not complete the works, and later entered a creditor's voluntary liquidation. Erith arranged for completion of the works, and the parties later disputed John Doyle's final account. After significant delays, an adjudication was raised and was decided in John Doyle's favour, but was found to be unenforceable by the TCC as a result of John Doyle's being in liquidation. John Doyle appealed. The decision of the Court of Appeal provides two lessons for the construction sector concerning the enforcement of adjudicators' decisions by companies in liquidation. First, that clear, evidenced, and unequivocal security is necessary before enforcement is possible. And second, where a solvent and paying party asserts set-off and counterclaims, enforcement is prohibited in most circumstances. So we'll look at each of those lessons now. So lesson one is that clear, evidenced, and unequivocal security is necessary when a company in liquidation attempts to enforce an adjudicator's decision. Security was necessary because John Doyle, who sought enforcement of the adjudication decision in its favour, was insolvent. Thus, if Erith was successful in later proceedings, the insolvent John Doyle would be unable to repay Erith unless there was sufficient security. John Doyle claimed it had provided sufficient security to Erith to allow enforcement to proceed. John Doyle's grounds of appeal were all dismissed on the basis that the company had not met the requirement that any undertakings or security being offered be evidenced and unequivocal and beyond argument. Lord Justice Coulson also stated that a judge should not be required to find an offer of security in on-the-hoof proposals or vague suggestions made in oral argument. The point to take away is this: if a liquidator of an insolvent entity wishes to enforce an adjudication decision, it must prove that any money received in enforcement proceedings will be sufficiently ring-fenced or otherwise secured to satisfy any future sums due as a result of further proceedings. Lesson two is that enforcement by a company in liquidation is rarely possible where there is a continuing set-off or counterclaim. So in this case, separately, the court attempted to rationalize the competing features of insolvency and adjudication to answer the question that the court said was lurking in the shadows, namely, whether a company in liquidation with an adjudication decision on its final account claim in its favor, but facing a continuing set-off and counterclaim, is entitled to summary judgment at all. I'll give you a brief overview of the relevant rules relating to insolvency set-off, as these rules apply in England and Wales, but similar provisions exist in Scotland. Insolvency set-off requires parties with mutual dealings to set off balances due to each other when one becomes insolvent. This avoids a solvent company paying debts owed to an insolvent company in full, but then only receiving as a dividend a pro rata share of debts owed to it by the insolvent company. Insolvency set-off does not sit easily alongside adjudication, given the latter aims to provide parties with a non-final award, saving time and cost. The chance of recovering payments in future proceedings from an insolvent company are so low that awarding money to an insolvent company via adjudication can have unintended finality. Because set-off and counterclaims by the paying party may not be met in full by the party in liquidation, the court is forced to consider whether enforcement without set-off or counterclaim should be allowed at all. A 2020 Supreme Court case made a step forward in the ability of companies in liquidation to pursue adjudication. In Bresco Electrical Services Limited in liquidation against Michael J. Lonsdale Electrical Limited, the court overturned a lower court decision that prevented commencement of adjudication in those circumstances. The Supreme Court held that there were legitimate commercial and tactical reasons a liquidator may wish to pursue adjudication, even if the circumstances might limit enforcement. But what might enforcement be? But when might enforcement be or not be available? The court in John Doyle considered that enforcement could be available for companies in liquidation where there is no dispute about a cross-claim, or where a cross-claim is made but is of no substance. However, enforcement could not be awarded where a cross-claim exists and required to be determined by the adjudicator. This is because an adjudicator's decision is necessarily provisional and cannot be regarded as a final determination of the net balance. Enforcing an adjudicator's decision in this situation would thus be incompatible with the insolvency rules. It's worth noting that the court's comments were obiter, that is, they are not part of the binding decision of the court. However, they are likely to be highly persuasive to future courts. So what lessons can we take from this? If the court's obiter comments are followed, there will be a three-stage process for companies in liquidation seeking enforcement with differing prospects for the liquidators. Firstly, and in terms of commencement, Bresco decided, and the John Doyle case reaffirmed, that insolvent parties can commence adjudications. Secondly, and in relation to enforcement and set-off or counterclaims, as per this John Doyle case, companies in liquidation can only enforce an adjudication award if there is no dispute about a cross-claim or if a cross-claim is of no substance. And thirdly, in relation to enforcement and security, even then, the party, and even if you've got this far, the party in liquidation must prove that it has provided clear, evidenced and unequivocal security. As Lord Justice Coulson states, in circumstances where the adjudicator has finally decided the net balance between the parties, then the consideration would move to security issues. I'll now return you to Chiara for our fourth case.
Thanks, Daniel. So our fourth case is Quadro Services Limited against Creoch Concrete Products Limited. Here, the TCC held that a claim referred to adjudication, which founded on 3 separate payment applications, was still a single dispute for purposes of adjudication. The adjudicator therefore did have jurisdiction to consider all 3 of the payment applications to determine the sum due, and the adjudicator's decision was enforced. So the parties in this case entered into an oral agreement for the provision of labour to Creoch Concrete. It was agreed that the contract was a construction contract for the purposes of the 1996 Act. The contract did not contain any adjudication provisions, and therefore the Scheme for Construction Contracts, England and Wales Regulations 1998 as amended applied. The works were carried out by Quadro and they made applications for payment and raised invoices. Creoch did not pay 3 invoices. 2 of the invoices had been approved, with Creoch confirming an invoice could be raised in line with the relevant payment application. Creoch failed to respond to the 3rd payment application or issue a pay less notice in response. And given this failure, Quadro proceeded to issue an invoice in line with its payment application. Creoch did not pay. So Quadro issued adjudication proceedings in relation to the 3 outstanding invoices. Quadro's position in adjudication was that there was no defence to its claim for payment for all 3 invoices, given Creoch's acceptance of the first 2 payment applications and Creoch's failure to respond to the 3rd payment application. Creoch raised a jurisdictional challenge in the adjudication, arguing that the matter referred to adjudication contained 3 disputes as opposed to 1. As you will know, the statutory position is that only 1 dispute can be referred to adjudication unless both parties agree otherwise. Quadro argued that only 1 dispute had been referred as to what were the outstanding sums owed to Quadro by Creoch under 1 contract. It classified the 3 invoices as sub-issues. The adjudicator agreed with Quadro that the dispute referred was only 1 dispute and issued his decision. He awarded Quadro its full claim, together with interest and compensation under the Late Payment of Commercial Debts Interest Act 1998. Creoch failed to pay. Quadro raised adjudication enforcement proceedings given CREAC's failure to pay. CREAC resisted enforcement on the basis that the adjudication covered multiple disputes. CREAC presented 4 reasons to support its argument. First, if claims can be individually decided, it strongly points to the conclusion that there are multiple disputes. This is the rule of thumb line of reasoning from prior case law. Second, the claims could be decided separately without reference to each other. Third, the only time the relevant invoices had been grouped together was in a demand letter, which also referred to 4 other projects. And fourth, the 3 applications are distinguishable, as the first 2 were expressly agreed, but the third was not. The TCC held that previous authorities do not state that if issues can be decided independently when they are automatically separate disputes as opposed to sub-issues of a wider dispute, that whether matters are sub-issues or separate issues is a question of fact, that the dispute referred to adjudication was the failure to pay £40,000 and £26,000, the total of the 3 outstanding invoices. If CREAC were right, the result would be that parties would be put to the very significant cost and inconvenience of numerous adjudications to recover a single claim balance under one contract. The TCC further stated this would be contrary to the policy underlying the adjudication process of efficient, swift and cost-effective resolution of disputes on an interim basis. The fact that the payment applications were cumulative meant that there was a clear link between them. So the TCC therefore did enforce the adjudicator's decision. The practical points to take away from this case for parties adjudicating are, for referring parties, when you're framing a notice to refer to adjudication, consider carefully whether you are referring one dispute, potentially with sub-issues, or multiple disputes. Establishing a clear link between any sub-issues will assist in future arguments. For respondents, when considering whether or not to raise a jurisdictional challenge, consider whether the issues are truly separate disputes or whether there are clear links between them, which may mean there are sub-issues as opposed to separate disputes. And for everyone, the fact that multiple payment applications or payment cycles are referred together will not automatically result in a court determining that multiple disputes have been referred, and the facts of the particular case will be analysed. It is also of interest that the TCC commented on the policy behind the adjudication process. This shows again the court's support for the adjudication process, and I think the decision also further demonstrates that the courts will look to enforce the adjudicator's decision unless there is a very good reason not to. So I'll pass you on to Tara for our final case.
Thank you, Chiara. Our 5th and final adjudication case of 2021 is Transport for Greater Manchester v Kia Construction Limited, trading as Kia Construction Northern. As listeners will be aware, adjudication decisions have interim binding effect. That is, they stand until and unless the outcome is reversed by a court or other tribunal if the parties agree. After an adjudication, parties can be left in an uncertain position, unsure as to whether their opponents consider the adjudicated dispute to be concluded or whether the adjudication outcome might be revisited in court or arbitration later. To combat this potential for uncertainty, construction contracts often set out steps that must be taken after an adjudication if a party wishes to have the outcome reviewed in further proceedings. Some contracts require that party to serve a notice of dissatisfaction within a specified time frame after the adjudication decision. The time frame, form, content, and method of service of the notice will generally be prescribed by the contract. In Transport for Greater Manchester against Kia Construction, the TCC considered whether a notice of dissatisfaction complied with the strict contractual provisions in the parties' construction contract, which was based on NEC conditions. If it did not, the adjudication decision was permanently binding and the outcome could not be reviewed in court. To give some background to the case, Kia Construction Limited was engaged by Transport for Greater Manchester to design and construct a bus interchange in Bolton. Kia applied for an extension to the contractual completion date for its works. which Transport for Greater Manchester rejected. The dispute was referred to adjudication, in which Kia was successful. Transport for Greater Manchester made payment of the sums awarded by the adjudicator, but purported to reserve various rights and issued a notice of dissatisfaction. Transport for Greater Manchester then commenced court proceedings, seeking a declaration that the adjudicator had erred in law and claiming repayment of the sums awarded by the adjudication. Kia sought a declaration that the TCC had no jurisdiction to hear Transport for Greater Manchester's claim. Kia's argument related to the notice of dissatisfaction issued by Transport for Greater Manchester. Kia argued, amongst other things, that the notice of dissatisfaction was invalidly issued because it was issued to Kia's solicitors rather than to Kia directly. This argument was based on the contract, which provided that contractual notifications had to be issued to a specific stated contact unless alternative contact details had been notified. Transport for Greater Manchester argued, amongst other things, that Kia had authorised communications regarding the adjudication being issued through its solicitors, that Kia's adjudication submissions identified Kia's solicitors as its representatives in the adjudication and provided their contact details for receiving communications, and that issuing a notice of dissatisfaction to Kia's solicitors was therefore valid for the purposes of the contract. The contract required a notice of dissatisfaction to be served within 4 weeks of an adjudication decision, if a party wished to preserve its rights to challenge the outcome. If Kia was correct that the notice of dissatisfaction was invalidly, did the court decide? The TCC held that there had been sufficient notification for the purposes of the contract, that the address for Kia solicitors would be the address for service of communications in respect of the adjudication. It was noted that Transport for Greater Manchester similarly issued all adjudication correspondence through its representative, and that neither party had objected to the other proceeding in this way. The notice of dissatisfaction issued by Transport for Greater Manchester was therefore valid, and Transport for Greater Manchester's challenge to the adjudication decision could therefore continue. So what can we take away from this decision? It is important to always be aware of contractual requirements regarding notifications. A failure to follow these can invalidate a notice, which may have significant consequences. If there is doubt as to where, to whom, or how a contractual notice should be issued, a reasonable approach may be to issue duplicate notices. The TCC's decision in this matter was dependent on the precise wording of the contractual clauses in question and the wording of correspondence between Transport for Greater Manchester and Kia. Disputes such as this are often dependent on the precise contractual wording and factual circumstances that apply. I'll now hand you back to Nathaniel, who will go through the lessons learned. Thank you.
Thank you, Tara. Thank you, Chiara. So that concludes our summary of the 5 cases we have chosen today. Just before we end, here is a final roundup of the main points from each of the 5 cases. Firstly, contract administrators must ensure that their payment notices truly reflect what they consider to be due. Also, an adjudicator's failure to consider a line of defence will render a decision unenforceable. Secondly, when entering into a collateral warranty, parties should consider whether they wish the option to adjudicate and should ensure the warranty states the agreed position. Thirdly, adjudication can be commenced by liquidators of insolvent entities, and the resulting decisions may be enforceable, but only where there is clear security over the sums to be paid, and generally where there is no counterclaim. Fourthly, it is possible to pursue sums due under more than one payment application in a single adjudication, but attention should be paid to the precise wording of the adjudication notice. And fifthly, a party that is dissatisfied with an adjudication decision should take care to review the contract to check any relevant notice provisions and ensure that these are complied with. We have now come to the end of today's webinar. We hope that this has been an informative look at some of the most important adjudication cases decided in 2021 and that you might find an applications for some of the lessons learned in your work through 2022 and beyond. If you have any further questions, please submit them using the buttons on your screens, and we will get back to you as soon as we can. An on-demand version of this webinar will shortly be sent to you all, should you wish to share it with a colleague or someone you think might be interested and benefit, or feel free to watch it again at your convenience. Thank you all for listening, and we hope you will join us again at some of our future webinars in 2022. Thank you.